Good evening, everyone. I'm Professor Sally Wheeler. I'm the Dean of the Australian National University's College of Law and the University's Pro-Vice Chancellor for International Strategy. And I'm delighted to join you from here in Canberra. Our audience tonight comes from across Australia, and we have guests from across the world. Let me begin, please, by acknowledging and celebrating the first Australians on whose land we gather today. For those of us who are in Canberra, it is the Ngunnawal Ngambri people, and I imagine that the other speakers who are in Australia will pay their respects to the traditional owners of the land that they're on as we go along. So let me pay my respects to the Ngambri and Ngunnawal elders past and present. So while we'll remember 2020 for its disruption on a national global scale, from bushfires in Siberia and Australia to the current COVID-19 pandemic, at our college it's also been an opportunity to unite and commemorate an important milestone, 60 years of law at ANU. And to celebrate this anniversary, we're proud to host our year-long Law in Focus series of events. From social justice, climate change to international relations, our panel discussions have drawn on the rich expertise of our legal scholars, alumni, and esteemed thought leaders. Tonight we're going to discuss a topic that has come under intense scrutiny this year: free speech at work. How freely can employees express their views? How does the constitutional doctrine of freedom of political communication apply? What implication do high-profile cases in Australia have on our discourse and our democratic debate? And we're pleased that you can join us tonight to explore these questions and more. I'm now going to welcome our very distinguished panel. Josh Bornstein, National Head of Employment Law at Maurice Blackburn Lawyers. Kate Eastman, Senior Counsel Barrister at New Chambers. Distinguished Professor Adrienne Stone, one of, if not the foremost constitutional law scholar at the University of Melbourne, and Professor Andrew Podger, a public policy scholar based at the ANU College of Arts and Social Sciences. I'm also delighted that one of our own law alumni is at the helm of this evening's discussion as moderator. Kieran Pender is an alumnus and visiting fellow at ANU College of Law. He's also senior legal advisor at the International Bar Association, an accomplished journalist and commentator on many events. And Kieran, we're very proud of you. Before I pass on to Kieran to commence the discussion, perhaps I could remind you that this webinar is a prelude for an upcoming conference on the same topic that we will host in person as soon as it's safe to do so, or as soon as we're allowed to do so. We'll keep you posted with details of that event in the coming months, and hope to see you all there. So Kieran, please start us off.
Thanks, Sally, and likewise I'll acknowledge the traditional owners of the land that we meet all around Australia and indeed around the world. Just two notes of housekeeping. Firstly, the ANU privacy policy mandates that I tell you all that this is being recorded. And secondly, that if you have any questions, we'll have Q&A at the end, and please pose your questions to the esteemed panel through the Q&A as we go along. As Sally mentioned, this was originally supposed to be an in-person event. We had scheduled a conference in May, a panel event of this nature, one evening, and a full-day conference the following day, an interdisciplinary conference to discuss these incredibly timely, topical and important issues. COVID obviously has precluded that, but we still very much intend to hold this conference in the future when it is safe to do so. And in the meantime, we hope this discussion this evening or whatever time it is, wherever you are joining us from, will provide some excellent food for thought as we wait for that gathering. When we were planning that in-person conference, we were really fortunate to have the support of Bradley Allen Love Lawyers, the Law Society of the ACT Bar Association, the Australian Academy of Law, the Institute of Public Administration Australia, and the Australian Labour and Employment Relations Association of the ACT. So I wanted to acknowledge their support, and we look forward, as I say, to holding that conference and panel event in due course. Before I begin with some questions for this incredibly expert panel we've been fortunate to gather today, and may I say it was very difficult to put together the panel because we had 30 or so speakers for our conference itself from different subject matters, different areas that touch on this multifaceted, complex topic. We could have picked any of them. They would have made for great speakers tonight. And so I thank everyone who agreed to speak at the conference, and I'm delighted to have such a distinguished panel joining us now. As if sort of by deliberate timing, but obviously not, this discussion this evening has only been underscored its timeliness, its relevance and its importance by a discussion of the full court of the Federal Court on these exact issues today in a judgment, the Reid judgment that was issued today. Given it only came out a few hours ago, we won't discuss it in too much depth, but all of the panel have read it, and it is something that goes to many of these issues. Issues that not only affect every Australian, either you are in the workplace and therefore these are issues that affect you, or if you're not in the workplace for whatever reason, these issues go to the strength and the quality of our democratic discourse. So this is something that affects every Australian. It's an incredibly divisive and polarising subject matter. People have very strong opinions on the ability of employees to speak freely. And we've seen this subject arise with the expression of views that fall both on the left side of the spectrum and the right side of the spectrum. And often we have different responses depending on the content that's being voiced. So I think those are issues we need to scrutinise. I think probably fair to say that there's been some inconsistency in different positions, and perhaps I myself are guilty of that. These are hard issues. I don't think there's easy answers. And another reason these are hard issues are because these are complex legal issues. This is an area that touches on constitutional law, employment law, and subcategories within that, discrimination law, whistleblower protection, and so on. All underscored by contested and vitally important questions of free speech. So with that prelude, let me begin by asking Josh and Kate, I think it'd be useful to get a sense of the scope of this issue. We've seen a number of high-profile cases in this area in recent times, which I know both of you have been involved in different capacities, the Folau case, the Banerji case, the McIntyre case. Are they the iceberg, or are they just the tip of the iceberg? In other words, is this a minor issue or a major issue? And how do you think this issue is changing?
Perhaps I'll start. Thank you for the question. I think it's almost impossible to know precisely the scale of the issue, because we certainly know of some very well publicised cases in Australia. And I might add, this is not just an issue confined to Australia. There are similar issues in the United States, in Britain, and other OECD countries. But I would suggest that there has been an increase in the number of cases of this kind because the behaviour of the private sector has fundamentally changed. It's quite a complex and multifaceted explanation, but bear with me if you can. First of all, I would argue that the reach of employer control is growing. So, for example, recently we have seen a number of cases in which consensual sexual relationships are sought to be regulated by companies through their employment contracts and employment arrangements. And that's, I think, a new development. But there are some fundamental drivers of private sector change in the last, I would say, 40 years. Some would argue, historians would say we're living in a new gilded age. Economists would say we're living in the neoliberal era, but whatever phrase you want to use, there are certain characteristics that big large private sector multinationals are commonly engaged in. We've seen a lot of evidence of aggressive tax minimisation, I think, diminution in employee collective bargaining power, employee bargaining power in the workplace, deregulation, and so on. And we've seen associated political and economic problems associated with increased inequality, a low wage crisis, and so on and so forth. Now, what's that all got to do with free speech at work? One of the I think responses or strategies that the private sector has developed in that context is a greater emphasis on brand management, and brand management being used to try and reduce the prospect of regulation, legislative intervention in that sort of context. So we've seen a professionalisation of brand management, a more sophisticated version of brand management, and I would argue that CSR programs, for example, are a form of brand management. Company value statements are a form of brand management. If you look at the scandals that have beset various corporations, BP, in Australia, we've had major scandals afflicting banks and financial services companies. We've had a recent scandal engulfing a big mining company, Rio Tinto, over the destruction of a 45,000-year sacred site, Indigenous sacred site. If you look at the company values, in almost each case, you will find the foremost company value is integrity. So, in my view, those programs, the company value statements and company policies, which are now being visited upon employees, are a form of brand management. At the same time, in the last 15 or 20 years, as this industry of brand management has grown, we've had an internet revolution. The ability of people to generate their own news, to speak to the world on a Twitter account, to participate in political debate. Technology has allowed greater surveillance by corporations of their employees, but it's also allowed people to participate in a way that could be argued to be quite democratic in some ways in public debate and discourse. Unfortunately, as we all know, the internet revolution has also heralded some very unsavoury behaviour, including mobbing on social media. So where you have controversy and mobbing clash with brand management, what you will find is increasingly employees' human rights are being sacrificed on the altar of corporate brand management. If an employee says something controversial that could be argued to be unpatriotic, in Australia, a number of employees have been almost driven out of the country and eviscerated because they have protested about the commemoration of war in the form of our national Anzac Day. And I would argue in those cases, we've had mobbing, and then in response to that mobbing, the brand managers move in, and the easiest way to deal with the protection of the brand is to eliminate the employment of the person whose views are controversial. So I think that's actually a multifaceted explanation of why we're seeing this happen more and more in our contemporary life.
Thanks. So Kate, iceberg or tip of the iceberg?
All right, so I'm going to start this off by being deliberately controversial and not agree with Josh, because we've got to have a little debate here. And I have a very different perspective to Josh on these issues. And I think it really starts with the employees and what it means to go to work and our expectations of our workplaces in terms of what we can and can't do. And I do think that what we've seen over the last 30 years is a sense of employees not just coming to provide labour for their employers, but an expectation that their workplace should be more than just clock on, clock off and get a paycheck, that the workplace has to provide safety. The workplace has to provide opportunity. The workplace has to give equality in the work that we do. And so our expectations as an employee has changed. And then with that is, I think, a greater sense of us as individuals, be workers or not, that we are far more aware of our rights and our sense to exercise what we call free speech. We hear that expression much more in Australian discourse than we've heard in the past. And I do think, I agree with Josh on this, is that the internet and one of these things absolutely has fundamentally changed how we communicate and how we express our ideas. In the past, it was very difficult for any individual person to get access to the media and have an op-ed piece published or to have their opinions published. So we often sort of looked at mass gatherings in the form of protests as our traditional form of exercising our free speech. But the use of the iPhone, of computers and the internet gives us a lot more personal freedom to express views in a range of different ways. And so if you ask if it's the tip of the iceberg or the iceberg, the tip of the iceberg, I think, are the cases that we've seen in recent times that may, in a sense, reflect the issues that Josh is talking about. But in terms of the deeper what lies beneath, is really a change in our expectations as workers to what we can and can't do in our workplaces, combined with our capacity to exercise our freedom of expression through social media. And so I sort of see that as the primary change rather than it being all about corporatized brand damage.
Well, thanks so much for those two very stimulating answers, Josh and Kate. Adrienne, come to you. In Australia, there's not necessarily a First Amendment, but we have an implied constitutional freedom of political communication in the Constitution. To what extent do we have constitutional protections for our employee speech?
So I think I need to come at that question a little bit sideways to give a sensible answer to it. So one question I'm often hear asked is, don't we not have enough protection for freedom of speech under our Constitution, and don't we need a First Amendment, right? We need a bit of text there that says that says something about freedom of expression and not just what we have. So the first point I want to make in response to that is that's a good question, but the First Amendment is not a good comparator, right? So the First Amendment is, first of all, it does contain very strong protection for freedom of speech. But it's almost entirely exceptional in world terms, notwithstanding almost every constitution in the world. In fact, every democratic constitution in the world contains some protection for freedom of speech. What you get under the First Amendment is completely different to what you get everywhere else. In particular, the First Amendment has this core, it's characterized by two things, I would say: doctrinal rigidity and this core non-redistributive principle that means that the state's not entitled to level the playing field for speakers. And as a result of that, there's a very straight line from that core principle to, the sort of nemesis of First Amendment law, which is the Citizens United decision recognising the unlimited right of corporations to spend in elections. So I just, given I think that many First Amendment scholars now talk about the First Amendment as being weaponized against the values from which it sprang. If we're going to have a comparative discussion, let's put the First Amendment aside. It's not a great comparator. So then the question is, let's look at what we have and how does it compare to something more mainstream in international terms, like say Section 2B of the Canadian Charter. Well, there are some differences, but here's where I think I differ a bit from what I think is the conventional wisdom. I think the failures that you see in cases like Banerji don't actually spring from the underlying constitutional problem. They're a failure to exploit what our Constitution really reasonably can be taken to have provided. And the reason I think this is that, look, it's fair enough to say there's nothing in the Constitution that says everyone has a right to freedom of speech, but the Constitution has these really important words in it: the Parliament shall be, both houses of the Parliament shall be directly chosen by the people. That's a very profound democratic statement. And the court has said that means we need all the information that you would need in order to make a true choice as an elector. That's actually potentially very powerful protection for freedom of expression. Now, it's maybe a little bit narrower than a straight out expression guarantee. So it'd be harder to bring things like, you know, ordinary artistic communication into the coverage of this. But in cases like Banerji, which is core political communication, the problem isn't in the coverage, it's in the weakness of the protection, right? Not in what it covers, but in how much protection it gives to it. And on that point, again, I don't think there's anything wrong with the underlying structure of the constitutional doctrine. In fact, the principle that we use to determine limits on freedom of political communication is imported from Canada. You know, this, every law student knows it, the structured three-stage proportionality test. So we actually have a really important piece of constitutional text that protects political communication, and then its limit and the doctrine limiting it, it's actually not just imported from Canada, it's ubiquitous around the world. So if the High Court of Australia is not, as I think it didn't in Banerji, providing adequate protection for freedom of expression, I don't think you can necessarily point the finger at the underlying constitutional problem. I think that there's something else going on, and there's something sort of deep in the reasoning of the court that needs teasing out. That might be all I'll say for the moment, because you probably want to get into the weeds of the decision later. But I'm overall, my view is that we ought to recognise the Australian Constitution contains very good protection for political communication if properly applied. And I don't think that this is frankly the finest decision.
We certainly will come onto Banerji as we progress. Andrew, I'll come to you now, and you may also bring up that recent High Court case. As the former APS Commissioner, I'm sure you've given a lot of thought to this topic. Why are public servants precluded, limited in their political engagement, and how has that changed over time?
I think it's very important to understand that the civil service, the public service, is an institution of our responsible government system. It's not explicitly referred to in the Constitution, but the High Court on a number of occasions has found implicit recognition of its particular role. And that goes back to a long way in history, back to Northcote Trevelyan in Britain in 1854, which started the idea that the public service should be a professional public service, employment based on merit, in order to ensure efficiency and to avoid nepotism and political interference. That line of argument was put more sophisticatedly, I think, by Woodrow Wilson in the US in a lecture he gave in the late 1880s, and he clarified why we should be separating politics from administration, saying that in a democracy, you've got two principles. You've got the democratic principle of rule by majority, but you've got the other principle of professional administration that's fair to all, that doesn't involve the tyranny of the majority, that constrains the political control of administration. Those two principles obviously have some tension, but they are both extremely important. And the values of that professional administration of impartiality and non-partisanship necessarily constrain free speech by public servants. The public has got to have confidence that the public service is in fact impartial and non-partisan. At the same time, good public administration does require public engagement by public servants. They need to professionally engage with external experts, with their stakeholders and so on. And so it's not as if there's to be no public engagement, but there are constraints on political comment. There are a large number of public servants, however, where political comment is not really an issue. It depends on what they are commenting on, how they comment, and what their particular role in the public service is. But for a very large number of public servants, it's a tax office, in Centrelink, all around the place, where, frankly, as long as their political comment is not about their immediate role, it is not a particular issue. Things have changed. Back in the 1970s, we had Regulation 34B, which was a blanket prohibition on public comment. That was removed in the Whitlam government, and there has been, over time, some relaxation. The Code of Conduct for Public Servants was rewritten after the Public Service Act of 1999, which identified the key values of a professional public service, including impartiality and nonpartisanship. And the guidelines on how this should operate were rewritten when I was the commissioner. Further guidelines, however, have had to come in, as was mentioned by our first two speakers, with changes in media. So we've had guidance to say, well, what does this mean in the context of the frequent use of social media? I think one of the problems is that a lot of public servants aren't quite sure what it means for them and what the distinction should be for different types of public servants and different types of comment and ways of commenting. And I guess we'll get onto the Banerji case shortly, but I think one of the positives in the Banerji case was the judgment by Justice Eastman, who set out 6 criteria that might be used to advise public servants on when and how they can use public comment. But before I get onto that, just one final comment. This issue of the civil service as an institution there and the Banerji case around it was not just about, in my view, about what are the limits to free speech by public servants, but it was also about protecting the public service from excessive political control. It was highlighting the importance of nonpartisanship, and I think there are messages there for politicians as well as there are for public servants.
Thanks, Andrew. I think to begin with, we've touched on both this issue in the public sector and private sector context. And obviously there are similarities and there are divergences. Adrienne, I want to come back to you. One obvious divergence is the implied freedom as traditionally understood has some application to public servants. Does it have, or are there other public law values and protections that you think have any application in regards private sector employees being terminated or dismissed or disciplined by their employers for their political speech?
I'm sorry, Kieran, the question is it different? Are there different values at stake in relation to
does the law, either as a matter of hard law or sort of at a more value-led level, is there any protection for private sector employees?
So the freedom of political communication, if that's really what I wanted to speak to, doesn't actually distinguish on the basis of there's nothing in the doctrine that distinguishes on account of who it is that is doing the speaking. It's not a speaker-based doctrine. The question is always this underlying question of, well, how important is the communication that is affected to the making of a choice in having the kind of political communication that means we can all make a choice. Now, so that's the first answer. The second answer is you look at the legislation that was at issue in Banerji, and what you always need when there's a constitutional challenge is you need to identify a legitimate end to which the law is directed, and then you consider the nature of the means. Now, the legitimate end to which the law was directed in Banerji was an apolitical public service. Now, it seems to me that there's quite a lot to be said for that as certainly a legitimate end, particularly in an age of political polarisation and populist attacks on expertise. It may well be that that's a really important end. My criticism in Banerji is actually in the way that the means were assessed as whether they were good means to that end. So I'll leave that aside. Now, with private sector employees, I don't think that there is such a good case for the state to be interfering in order to make, for example, to require that other employees be apolitical. I can't see any interest it would have in private employees of an ordinary kind, we might think of a special kind, being required to behave in an apolitical way. But there might be reasons, there might be other reasons why you could find a legitimate end. But I think they'd be narrower in respect of at least ordinary private employees. So the question is really, what would be the legitimate end at which we would direct private employees to limit their speech at work? And we need to look at that on a case-by-case basis. I think that the category of legitimate ends would be narrower with respect to private employees.
Thanks, Adrienne. Kate, I'll come to you, and continuing on the private sector dimension of this. Obviously, the constitutional overlay is less pronounced because the Constitution doesn't directly restrain private employers, but there's a whole suite of employment and anti-discrimination law that can come up in this context. Can you talk to some of those issues that have arisen in some of this recent discussion and case law?
I think the starting point is to look carefully at what is the relationship between employer and employee and what underpins that relationship in a private sector environment. And so if you start by looking at what is the contract of employment, there may be written terms and conditions about complying with relevant policies, complying with standards and codes of conduct. But there's something much more fundamental in the employment relationship, and that is the implied terms that sit behind the relationship. And one of those implied terms is a duty of loyalty and fidelity to the employer. And the other important implied term is that where an employer gives a direction, that direction must be a lawful and reasonable direction, but other than that qualification, then that reflects the powers of the employer in that relationship. So from a contractual perspective, if you come back to those questions of duty of loyalty and fidelity to an employer, that is really the underpinning to the things Josh was talking about earlier. So we've seen in the private sector employment that employers have got an interest in protecting trade secrets, company secrets, and confidential information. And so for many employment lawyers, we're very familiar with dashing to court on very short notice to get orders restraining an employee disclosing confidential information or trade secrets that might harm the employer's business. And the disclosure of confidential information might be said to be done in the context of an employee's right to free speech in terms of sharing that information. But there's a prevailing interest that has to be assessed often by a court and by balancing the competing rights and interests as to whether or not those secrets should be maintained for the interests of the employer. So we've seen these issues sort of played out in the context of trade issues where employees may take the secrets of their former employer to use in a new business. But I think one thing that sort of changed in terms of the legal relationship on looking at lawful and reasonable directions and the duty of loyalty and fidelity is another element, and that is the obligation of employers to provide safe working environments. And traditionally that's been safety almost in a physical sense that we would look at from an OH&S perspective, for example. But we see over more recent years laws that have expanded the concept of the duty of care in an employment relationship, and laws such as discrimination laws that identify that certain forms of speech in an employment setting cause harm to other employees. And the impact of the harm of words in a workplace is certainly something which has really affected when and how speech may be regulated in an employment setting. So things like telling crude or rude sexist jokes, that can end up being contrary to laws dealing with sexual harassment. And so there's a sensitivity now about the language that's used in workplaces around sexism. But we see this really in a pressing sense where racial vilification and racist speech in a workplace creates significant harm for employees, and there's an obligation on employers to curb that speech against the impact of harm. And I think one thing I've really reflected on over the last 30 years in looking at these issues and coming as a law student saying, sticks and stones will break my bones, but words will never hurt me, so free speech always prevails, is understanding the impact of harm on fellows in workplaces when we spend a lot of time together at work, and how pervasive putting people down by the language that we use based on race, LGBTI status, gender, age, or disability can have a profound impact on a person's life. Now, whether you might want to have a debate about should that be the employer's obligation to regulate, or should the regulation come from somewhere else, that may be a question for another day. But I think we better understand the impact of harm, and that seems to have been a significant shift in terms of employers' obligations to positively regulate workplaces and curb speech and other forms of behaviour. So I think these are factors that come into play in terms of the complexity of when and how we regulate workplace speech, both internally in workplaces, but then also that external manifestation of speech. And I suppose the tricky question is how far can employers go in regulating what an employee says or does outside the confines of a normal workplace. And I think what we're in currently in a COVID-19 world where most people are working from home and not in a traditional workplace. And so that itself is going to test the boundaries about what is work and what is the employer's power to regulate what an employee says or does outside the workplace. So probably in a year's time or so, we can reflect on how COVID-19 has also been another shift, both culturally in our expectations for what employers should do, but also our responsibility as employees.
Just a quick follow-up there, Kate. I mean, you mentioned that the law, sounds like from what you've said, there's some uncertainty. We've seen a lot of litigation of this issue in the public sector context. We've had the Bennett case, the Gaynor case, the Starr case, now the Banerji case. To what extent is the law settled in the private sector? I'm reminded the Industrial Relations Commission once famously said that an employee is entitled to a private life. Is that still true?
I think there's a few aspects, Kieran, on that. The first is the extent to which codes of conduct are incorporated into the employment obligations or simply sit as guidelines for how employees should behave, so that what becomes a contractual obligation and what not, there's still some uncertainty about that. The second thing, which I think pops up in the Reid case that comes out today, is even if there is a code of conduct, to what extent does a code of conduct constitute a lawful or reasonable direction? Now, probably lawful, but there may be some shades of grey when it comes to what is a reasonable direction, and whether or not we look to constitutional law principles or we look to common law principles of what is reasonableness or what is proportionate in terms of the types of things that can be in codes of conduct. And then the third area is, does a work relationship and a workplace now have porous boundaries? And so what happens in a person's private life that can make its way back to the workplace or have an implication in the workplace, to what extent is there both the obligation to regulate or the obligation for an employee to curb their behaviour even outside the workplace? And this is a very tricky issue. One of the recommendations coming out of the Respect at Work report that Kate Jenkins has done is the question of that employers should have a positive duty to prevent sexual harassment occurring. And does a positive duty mean regulating out of work conduct because it may have an in-work context? So there's a great uncertainty at the moment in terms of where are the boundaries and to what extent is there transgression of traditional employment boundaries, that the law has got some work to do in terms of regulating both in terms of rights but also in terms of obligations.
Josh, coming to you now, you're a plaintiff lawyer, you often act for employees. If I get fired tomorrow for my intemperate tweets, in light of what Kate has just said, what are the first things that are going through your mind when I pick up the phone to you and ask for advice as to how to proceed?
Sure. I might just respond to some of what Kate said and then address that question more specifically. So I think the whole question of there needing to be legitimate restrictions on speech is not controversial. I think everyone accepts speech that harms has been regulated since Adam. And what goes on inside a workplace where people are racially abusive or sexually harass others, again, largely uncontroversial. These are, putting aside the employment contract, there's been statutes for 30 or 40 years in that realm, which passed by the Parliament, no issues. What has happened though is increasingly corporations are seeking to regulate the out of hours conduct of their employees in nefarious ways. And I think a fundamental disagreement I have about this is when we go to work, we may sell our labour, but we don't sell our right to participate in a political protest, to have an unpopular opinion about Anzac Day or some other controversial issue, and in effect to be subjected to some nefarious morals clause, which the precise contours of which we will never understand. If you go back to 1920s in Hollywood, in response to a controversy that engulfed an actor at that time, Hollywood production houses introduced morals clauses for all their Hollywood talent. And that essentially said, if you do anything that brings disrepute upon the industry or the company, you're going to be sacked. And it was used to regulate the sexuality of gay actors at that time. It was invoked against the Hollywood 10 during the McCarthyist era to sack them and blacklist them. And what's happened 100 years later is that by dint of the employment contract and generic policies which require everybody to comply with notions like respect, transparency, accountability, and so on, we have all been bound by morals clauses. We don't earn Hollywood salaries. We can be on minimum wage and have the same nefarious obligation. And that is fundamentally wrong and unfair and dangerous to democratic discourse and democratic health. So I've got a very different perspective about that. If you go to codes of conduct, they will require you, they're all very similar, and they're all incorporated by template contracts which say to the employee, you, the employee, are bound to comply with the code of conduct, but by the way, we, the company, are not. So after the Royal Commission into the banking and financial services sector, which saw revelations of corruption, criminality, and a huge range of misconduct, not one employee, am I aware, was accused of breaching the code of conduct. There were potentially thousands of banking employees engaged in this conduct. There was no single employee about whom it was alleged there was a breach of the code of conduct. One employee makes a controversial comment in church, which is captured on iPhone, or at a public rally, or on Facebook, posting a flag, a rainbow flag. All hell breaks loose because the brand management moves in and there's an attempt to liberate the career opportunities of the employees. Now, when employees are in that situation, to address your question more directly with that lengthy introduction, everything is about context and the facts, as all good lawyers will know. Is this private sector? Is this public sector? Fundamental issue. Has the person been sacked or not yet sacked? Another fundamental issue. If they're not yet sacked, I usually have more options. What is the contractual setting? Is there a collective agreement? Is there a union agreement? In universities, where a lot of these cases have emerged as universities have become corporatized and brand management has infected the university sector, there are still enterprise agreements which confer rights about academic freedom and disciplinary processes that we can invoke. So in the case of Ros Ward, who posted a humorous version of the Australian flag as a rainbow Marxist flag of some description, I haven't even seen the image. When she arrived on my doorstep, we were able to position ourselves to go to the federal court to seek an injunction. And we had the support of a union who was going to publicly campaign. And in that context, the university gave in, backed off, and she kept her job. Most people are not in that situation where they've got union backing, a collective agreement, and mostly they come to see me after they've been sacked. If they're in that position, then we're looking at the employment contract, usually a desert of rights these days for employees because they're largely drafted by employer lawyers and they're very lopsided, very few rights that we can engage. And then we look to the Fair Work Act at protections against sacking for freedom of religion or political opinion, or what are known as the adverse action provisions. And so those are considerations in each case. And then there are a raft of other anti-discrimination laws in Australia. We've got quite a complex patchwork of anti-discrimination legislation at both federal and state level. Obviously, when you're acting for an employee who's been sacked, the imbalance in resources is a critical issue. In Scott McIntyre's case, I took that on pro bono and I managed to get 2 or 3 silks in Sydney to act pro bono, and we would have easily pumped $500,000 of pro bono legal services into that case before it resolved. So that's a huge issue in these cases, but it's a huge issue in any employment case, unless you're dealing with the very top 3% of the labour market. But those are some of the considerations that inform what I do with employees in this situation.
Thanks, Josh. Well, I have you on speed dial should I ever need legal advice in that regard. Andrew, coming back to you, it's often said that hard cases make bad law. And I think something that concerns me about this area is that a lot of the cases we see going forward and going to judgment are at the more extreme end of the spectrum of behaviour that might come up in this issue. So, the Banerji case, her tweets were certainly fairly forthright. Israel Folau's commentary, even the most recent example, the Victorian Deputy Chief Health Officer, whatever you think of the substance of her tweets, they certainly were somewhat controversial. Is it a problem, do you think, that our laws and our understandings are being shaped by the extreme end of the spectrum? We had a question, for example, about someone in the immigration department tweeting about climate change. Those aren't the cases we're seeing in the High Court. Is that a problem?
Well, let's go back to the Banerji case for a moment, and Justice Edelman's suggestions of 6 factors that might be taken into account on whether the speech actions were a breach of the public servant's obligations. And I think what we need is for the Public Service Commission now to take those into consideration in its guidance to the public service about exactly what they believe the constraint really means. The first of those factors was the seniority of the public servant. Now, interestingly, Banerji herself is not particularly senior. So in her case, I think it was the combination of her being a middle-level public servant and the other factors. Let me just quickly, the other factors about whether the comments concern matters for which the person has direct duties and how the comment might impact on that. The location of the communication on a scale from vitriolic criticism to objective and informative policy discussion. Whether the person intended or could reasonably have foreseen that the communication would be widely disseminated. Whether the person intended or could reasonably have expected that the communication would be associated with a public service, and what the person expected or could reasonably have expected an ordinary member of the public to conclude about the effect on the public servant's duties and responsibilities. Central here is, are the actions likely to hurt the public confidence in the non-partisanship of the public service? If you went through those criteria, you could talk about that in the guidance and basically say, for the vast majority of public servants who are not senior people, who are just making a political comment, say on climate change when they're in the immigration department, there is nothing wrong with that. I think it would be wise if they used temperate language and they did it in a way which is not likely to hurt their own or their organisation's reputation, but that's not the core factor. It's about coming back to what Adrienne talked about. The legitimate end here is about the non-partisanship of the public service. So I hope this does lead to some clarification for the vast majority of public servants that there is nothing wrong with them participating in the political process and making comments, but they should have some caution about the way they do it. That's all that's really required. I do think it's also important to look at the other side, and one of the things that worried me about the change in the Public Service Commission's advice on social media, when it first came out, I thought it was very useful when the first point it raised in the guidance was using social media for professional discussions with external people and so on is something to be valued. It was something that's important and ought to be part of developing a public service that's well informed and able to offer good advice and have good administration. So participating in public discussion is in fact quite important, but the matter is how and the way in which it's done and who's doing it. So I think that has been lost in the guidance, that there is a danger here that there's going to be a political intrusion to constrain public servants beyond what is appropriate. One final comment about the Banerji case. The case doesn't actually go into whether the penalty was appropriate for the offence committed. And I do wonder that had she been cautioned early on and given an opportunity to change her behaviour and a suitable approach, that would have sufficed. If she had continued, then there might have been some acceleration, say a fine or a demotion, or a movement from her from one place to another. I do think sacking her turned out to be a pretty tough thing. If it had been handled differently, I think the situation might have been a lot better.
Thanks, Andrew. We're running close to time, so I'm going to ask each of the panelists 2 final quickfire questions, and then we'll go to some of the Q&A. So if you have more questions for the panel, we've already had some great questions, but please keep them coming through. The first question I have to each of you, and please keep your answers short, where do we go from here? You know, what's the next development going to be in this sphere? Adrienne?
Well, I think it's important to realise that we've got really good, potentially very good constitutional protection for freedom of expression if it's properly exploited. And incidentally, just to return to a point you made earlier, there's no reason why it couldn't apply to private employers. You need to show that that there is a law that burdens political communication, but private employers, if they are to dismiss their employees, are relying either on statute or common law, both of which are subject to the freedom of political communication. So my view is the High Court's actually been quite good with political communication in another context in relation to political protest, and something of the sort of energy and commitment to political discussion that is evident in those cases needs to be brought into the employment context.
Kate?
I think if we had a human rights approach to understanding the importance of the right of freedom of speech to an individual, but accepting that right is not unlimited, and then it needs to be appropriate balances in looking at restrictions or limitation on freedom of speech, that would create some certainty in terms of the way in which speech is regulated in an employment context, and allow the particular context and circumstances to be taken into account. So in a sense, it's taking that constitutional framework, but reflecting the general human rights approach. So Article 19 of the International Covenant on Civil and Political Rights, for example.
Josh?
Obviously, I'm pretty uncomfortable about the extent to which the private sector now is given the power to, in a sense, determine very complex questions about human rights and the limits of speech and whether speech is harmful for conduct outside the workplace in particular. I'm more comfortable about public sector restrictions for the reason that these debates have occurred in parliaments, democratically elected parliaments, where the question of the balancing of rights and responsibilities is at least debated and argued as part of the democratic process. I think there needs to be a rebalancing in the private sector, but I'm very pessimistic about that happening. I don't see it happening in the near future.
And Andrew?
On the public service, as I said, I think better guidance from the Commission, which might help the vast majority of public service to understand the balance between their freedoms and their responsibilities. The second point, however, is a different one, is that I think there's a case for strengthening the rules of non-partisanship amongst senior public servants. This is not so much about freedom of speech, but I do think we have a problem at the moment of insufficient emphasis on non-partisanship in senior appointments.
That was, I think, on display at the Senate today in the context of the sports rights affair. And I agree entirely with that position. It's very difficult to expect high standards of impartiality from lower level public servants in the context of some of what we see at the upper echelon at the moment.
Great. And final question for you all. Is a resolution to this conflict possible? I mean, we've heard today differences of opinion. There's differences of opinion in court judgments, in academic writings. You know, on one hand, employees want to be able to speak freely and they don't want to have adverse employment action as a result. Employers, whether public sector or private sector, have concerns about that speech. Are we going to come to a consensus in the future, or if you'll excuse the literary analogy, are we just waiting for Godot? Adrienne.
So free speech, a commitment to freedom of speech produces disagreement. It will always be the case. We all agree that it's a good idea and we disagree deeply about what it means in particular cases. And so I don't think that should even be our aim, to resolve it and reach a consensus. What we need to have is good processes and a good both public and legal discussion of the nature of our fundamental commitments. And in that respect, I think there is a lot of room, to just ride my favourite hobby horse for a moment, to really invigorate properly the freedom of political communication.
Kate?
I agree 100% with Adrienne, so I'm not going to add anything else, but I absolutely agree with everything that Adrienne's just said.
Josh?
So I'm going to disagree with Adrienne because from a very practical plaintiff lawyer perspective, when you're in a conference with your client and counsel and someone says, let's take the constitutional point. Immediately, you see $2.5 million in legal fees up for grabs. So, and we're trained as plaintiff lawyers who act for people with scarce resources to try and get from A to B in the most cost-effective way. I would love to run you these arguments, Adrienne. I would adore it. But all paths lead to appeal points and the High Court, and I'm not sure I'd be acting in my client's best interest if I took that approach.
Okay, so let me just say this, since you're disagreeing with me. The Constitution is always the last line of defence, not the first line. So obviously, almost all cases can be resolved on other grounds, right? But I do think that, but the question is, what do I think in my field needs to change? And I think that there's a lot more that it could be doing. And I think that the Constitution has a kind of flow-on cultural effect. That if we can make some progress here, it will help the rest of the problem. So I take your point completely.
And finally, Andrew?
I don't think I've got anything more to add. I did feel that the Justice Edelman material was very useful and should be taken into account very closely by the Public Service Commission.
Sure. My only criticism of Edelman's, I think, very sensible advice is I'm not sure where that comes from. It's not necessarily grounded in the Public Service Act or in the prior guidance. So my position would be, well, that's all well and good, but where does it come from? But others may disagree with my point.
Kieran, would I be wearing out my welcome if I just said something about
no, of course.
Judgment? So, I mean, Justice Edelman's judgment really does catch your eye, right? Because the problem with the position that the Banerji case leaves too many public servants in is that they just don't have, enough guidance about what's permitted and what's not. And his judgment gives you some, a better foothold. The problem is public servants shouldn't be in the position of having to rely upon statements found in one judgment of the High Court. That needs to be taken into the regulatory sphere. The problem with the law at issue in Banerji was not the aim to which it was directed, but just a lack of clarity in what's permitted and what is not. So Edelman's judgment is really something that law reform needs to take forward.
Yeah.
Can I just add on that? I've put an emphasis on what the Commission can do. The Commission doesn't only give guidance, the Commissioner issues directions. So there are a range of things that could be done in that field.
Great. We've got 10 minutes left before we'll have overstayed our welcome and have to wrap up. Some great questions coming through. A practical one to start with, I thought I'd ask Kate. Someone asked, is the disclaimer in our Twitter biography? I mean, mine says my views are my own. Is that enough? Does that help us?
That's easy. No.
Fair enough. I like succinct answers. We had a great question come in via email, and we're going to have someone speak particularly on this during a panel on the conference itself. Obviously, we'll have to wait until COVID allows that. But is religious speech different? And I know the government proposed a Folau clause in its draft religious discrimination bill. That hasn't gone anywhere, probably because of COVID. But does anyone want to comment? I know it's a fraught question, whether religious speech has any special status in this debate.
I'll venture in on that. So I think it's the nature of what you mean by religious speech. And do you mean in terms of proselytizing? Do you mean in terms of talking about religion? Or do you mean that in the name of your religion, that gives you license to say whatever you wish about somebody else? So I think there's a question of context there. And I think the drafting of the religious discrimination bill highlighted the difficulty of trespassing into an area which is a discrete and separate right, and trying to sort of combine what is essentially a freedom of expression issue against what is a very personal thing, which is your religious beliefs, be they organised religion or otherwise. So the devil's in the detail, if I can use that word, but the devil is in the detail in terms of the context in which you're considering religious speech.
Josh,
I have something to say in terms of how the US look at this, and you can see how difficult it's become.
Yeah, certainly. Josh, we've had an interesting question for you. Given your views on code of conduct, does your employer have one?
Yes, I believe we have a code of conduct, and to date I haven't been subject to any disciplinary process, but if my Twitter feed is ever focused on too much, I could be in trouble. But I'm to use the same reference to the Twitter handle, which says these views are not the views of my employer. I think my employer's given up trying to regulate my opinion and accepted that my views are sometimes different to others who I work with. And I would hope, in fact, in most workplaces, we're not automatons who agree with each other all the time. It'd be very boring if that was the case.
Mm. Fortunate for you that your employer hasn't reviewed your Twitter feed too carefully, perhaps. Adrienne, we touched on this before, but to go into a bit more depth, we had a really good question about the role of the implied freedom and employment law and contract law in terms of, I guess, private sector contract law. So if the starting point is the implied freedom doesn't bind as of right private sector employers, the level down on that is, but in the Lange case, the defamation law of Australia at common law was altered to permit the implied freedom. So is it possible that we might alter the bounds of employment law, contract law, on the same basis?
Yes, of course it is. So let me just step back. One of the points that's often made about freedom of political communication is that it is both negative in the sense that it stops interference with your rights rather than entitling you to something. And it's vertical. It applies as against the state rather than, at least directly, as against private persons. Now, confusingly, actually that's very common with constitutional rights. Both the First Amendment and Section 2B of the Canadian Charter are both negative and vertical in just that sense. So I don't think that's a problem really. It's not really, I don't think of it, it's helpful to think of, does it apply to a particular employer? What the freedom of political communication does, it's a standard against which the validity of laws are judged, right? And so in Banerji's case, there is actually the Public Service Act and the codes under it, which governed her. But if a private employer is to enforce a code of conduct, they're relying on some law, some statute or some common law, and that has to be also judged against freedom of political communication. So just as I think it's another way in which I think we need to understand this is a doctrine with just a lot of potential to reach into private employment relationships. And that's important. I mean, I don't think under the Constitution, employees should be able to contract out of the collective commitment we have to having a parliament that is directly chosen by the people. And I don't think the High Court would allow that. If you looked at its decisions in the defamation area, that would be one area that makes it clear. And, you know, in comparative contexts overseas, you see exactly this kind of reasoning leading to, you know, at least some constitutional supervision of the private sphere.
Maybe two final questions and then we better wrap things up. Firstly, for you, Josh, you acted for Scott McIntyre. A question that's come through is, what is the position of public sector journalists for the ABC and SBS, given they're both, in some regards, public servants, but also journalists, which has its own sort of freedom of press element to it as well?
The short answer to that is they're terrified. There is a huge problem in those institutions because of concerted political attacks over 30 or 40 years, which have, I think, caused a organisational post-traumatic stress disorder throughout those organisations. So that's the setting about those organisations. Now, in the case of SBS, it's a statutory corporation. It has its own code of conduct. And in the Scott McIntyre case, it encouraged journalists to engage with social media through the employment contract and the code of conduct, but not to do so in such a way as it might bring SBS into disrepute. It didn't provide any guidance about that. It didn't discuss the difference between tweeting during working hours or tweeting about a work-related matter and not doing that, but it was the foundation for the sacking. The ABC, I'm just wondering whether I've had a look at any ABC cases. It has its own act as well, but again, I think there is a code of conduct and there's also an industrial agreement that applies. I think it's a similar setting to SBS, but I think the issues that more powerfully impact what happens with journalists at those two organisations is the issues I talked about at the start. There's a huge fear and self-censorship that goes on for employees of those two institutions these days. And remember Yasmin Abdel-Majid, the case of Yasmin Abdel-Majid, who did a 5-word tweet about referencing Anzac Day, lest we forget, but she referenced Palestine and other things. She withdrew it, apologised, and then was eviscerated by the Australian newspaper, 120,000 words of evisceration until she was driven offshore. But one of the backstories to all of that is the ABC ceased her employment. So within the confines of those institutions, there is a huge amount of fear and self-censorship.
And final question, maybe Andrew and Kate, proportionality, it's already come up. We had a question about the disciplinary decisions and the proportionality. Do you think we'd have less tension and less conflict in this particular area if employers were a little bit more trigger shy with pulling the dismissal button and used sanctions of a more moderate nature to try and engage constructively with employees on this topic? Andrew and then Kate?
Absolutely. I mean, I do think it's really important, but there needs to be some guidance from the Commission. But I do think a process of counselling where there's a person that would have seemed to have crossed the line, and there are a lot of things you can do short of dismissal. I would be a little bit firmer if there was behaviour by a senior executive officer. Then you might move more swiftly if the person was really quite clearly showing partisanship.
And final word for Kate.
Look, I agree, but often what happens when issues like this arise is that there'll be, in the private sector and also in the public sector, an investigation. And often the investigations can be lengthy and the investigations themselves can create further harm and damage to the employee, to the morale, to others. So I think we need to find better ways of resolving disputes where we have differences of opinion, but also building cultures that understand and respect what freedom of expression means. And it's not just a right, but it also carries with it responsibility. So yes, I'm harping back to Article 19 of the ICCPR, but understanding that and building a better culture in workplaces may alleviate some of those sort of extreme outcomes for both employee and employers.
I'm delighted to say I agree with everything you just said. Everything.
Finally.
Workplace investigations are a mental health disaster area.
Yeah.
Well, thank you all very much for your time today. A fantastic panel discussion, such an important and complex issue. And I think we've only just started to dig into it. That's why we've scheduled a whole one-day conference on it for as soon as COVID allows. So let me thank the panel. Let me thank Jan and Tom at the ANU for their work behind the scenes, Sally Wheeler and the ANU College of Law for supporting this event and supporting our plans for a conference on this topic. And let me thank all of the audience for your excellent questions and active attendance. So thank you very much. Have a good evening, morning, wherever you are.
Thank you, Kieran.
Thank you, Kieran.
Thanks, Kieran. Thanks, panellists.
Thank you, everybody.